Welcome to meeting number 70 of the House of Commons Standing Committee on Government Operations and Estimates. Pursuant to the motions adopted by the committee on Wednesday, January 18th, 2023, and Monday, April 24th, 2023, the committee is meeting on the study of the federal government consulting contracts awarded to McKinsey and Company. And now, in accordance with our routine motion, I'm informing the committee that all the witnesses attending by video conference have completed the required connection tests in advance of the meeting. Colleagues, we have two opening statements and then a very short commentary by our law clerk. Mr. Shea, I understand you're starting with the opening statement. Please go ahead.
Bonjour, Monsieur le Président et Mesdames et Messieurs les membres.
Good afternoon, Mr. Chairman, members of the committee.
Office to provide information about the government's response to the motion for production of documents concerning contracts awarded to McKinsey and Company. Je m'appelle Matthew Shea et je suis...
My name is Matthew Shea. I'm Assistant Secretary to the Cabinet, Ministerial and Affairs.
For contracts signed by the government on their behalf. The public service is committed to ensuring procurements are conducted in a fair, open and transparent manner and in accordance with Treasury Board policies, regulations, guidelines, trade agreements and procedures. Nous sommes également résolus à rendre...
We are also liable for accountability. I respect the role of Parliament, which consists in asking for responsibility for the government, accountability, and provide information in a transparent manner to parliamentarians. No effort is spared on this whole scale of the public service to respond to the request for documents from committees.
20 organizations were mobilized with collecting, reviewing, and translating documents with an estimated total volume of over 220,000 pages. As many of those pages as possible were provided to this committee by February 22nd. Completing the remaining translation and providing all documents in both official languages is a priority. La fonction publique est aussi résolue.
The public service is also keeping with transparency, committed to transparency. The long-standing approach over successive governments has been to balance the commitment to transparency and the need to protect information.
Third-party information that represents a commercial sensitivity. Upon learning that McKinsey provided its material to this committee in an unredacted format, we engaged the company to lift redactions wherever possible. Le comité continuera donc.
The committee will continue to receive revised packages with minimal redactions as a result.
Questions related to the status of their departmental work. Je passerai maintenant.
I'd like to give the floor now to the documents provided by the PCO.
The Privy Council Office issued one sole source non-competitive contract to McKinsey
In 2017 in the amount of $24,747 during the period for which the records were requested. Of the 280 pages submitted by the Privy Council Office, redactions remain in 2 paragraphs that relate to cabinet confidence. Mr. Chair and members of the committee, thank you for the opportunity to provide with this context. All of us on the panel look forward to answering your questions this afternoon.
Thank you, Mr. Shea, and Mr. Ledoux for 2.5 minutes. Opening statement, please.
Good afternoon, Mr. Chair and members of the committee. Je tiens à remercier.
I would like to thank the committee for its invitation, and I'm quite pleased to have the opportunity to respond to any of your questions.
Is the professional investment management organization that invests the Canada Pension Plan funds not currently needed to pay current benefits. Our purpose is to help provide a foundation upon which more than 21 million Canadians can achieve lifetime financial security. Our assets are segregated from government funds, managed exclusively to pay these benefits. The organization's framework was carefully crafted to ensure we operate without political interference. When Canadian governments decided that a national pension fund was needed to address poverty among seniors, consent of the provinces was required. Maintaining provincial authority is deeply enshrined in the Canada Pension Plan, arguably the best example of cooperative federalism in Canada. Joint stewardship between federal and provincial government applies to how we operate. We are focused solely on fulfilling our legislative objectives in the best interests of contributors and beneficiaries. Pursuing complex investment opportunities requires significant and multifaceted due diligence. To provide a sense of scale, over the last 5 years, we carried out more than 300 investment transactions, more than that, but these 300 investment transactions, each one of them were valued over $300 million. Disclosing commercially sensitive material would severely undermine our ability to achieve our mission. Our success in capital markets depends on our ability to work with partners confidentially, shielded from politics and competitors. Most critically, political demands superseding our commercial activities would erode the fund's position in the most important investment markets in the world. For example, the U.S. grants special trusted status on CPP investments because we are independent and behave independently. Anything that compromises our respected commercial position would hinder our ability to access and compete in global markets. And that's contrary to the best interests of Canadians relying on the CPP for their retirement. Je remercie le comité.
I thank the committee for this opportunity, and I'd be very pleased to respond to your questions.
Thank you, Mr. Leduc. I'm now going to turn things over to Mr. Bedard for a few moments. Might have a opening commentary.
Thank you, Mr. Chair, and thank you, members of the committee. My name is Michel Bedard, and I am the interim law clerk and parliamentary counsel for the House of Commons. Thank you for the opportunity to explain and clarify the right of the House and its committees to send for papers and records. As the grand inquest of the nation, the House of Commons has the right to institute and conduct inquiries, as well as to send for papers and records. These rights are part of the House of Commons privileges, immunities, and powers, oftentimes referred to as parliamentary privilege, that are constitutional in nature, as they are rooted in the Constitution Act 1867, Section 18, and its preamble. These rights and the fundamental role of the House of Commons and its committees have been recognized by the courts, including the constitutional nature of parliamentary privilege by the Supreme Court of Canada. Il n'existe aucune limite.
There is no limit to the authority of the House of Commons or its committees for the production of documents, insofar those documents exist either digitally or a hard copy and are found in Canada. This power grants no exceptions to the committees and the House of Commons, but are explicitly granted. This power allows them to obtain the information required for any investigation and balances its role as the judge of these copies and the judgment to request information in the context of reports that they may be studying.
With a confidentiality claim, a committee has a number of options. It can decide not to insist on the production of the information or part of the information. It could also choose to put measures in place to safeguard the confidential nature of the information, such as considering the information at in-camera meetings. Or the committee can simply maintain its original request for information and insist on the production of the documents unredacted. Merci. Ceci termine mes.
Thank you. That would conclude my remarks, and I'd be prepared to answer any questions from the committee.
With Mr. Barrett for 6 minutes, please.
Well, thanks very much, Chair. Mr. Shea, are you familiar with the law as it has been described by the previous speaker, by the parliamentary law clerk? A yes or no would be great.
I am not a legal expert.
Okay. So, are you aware with the Parliament of Canada having constitutional power without limit to send for papers. Is that something that you are aware of, sir?
I don't think it's a simple yes or no question because
Well,
there
in
are
fact-
other
in
privacy acts and information acts that apply.
Okay. Well, I'm not going to waste the committee's time and have the previous speaker, the law clerk for the House of Commons, re-explain this to you. This isn't something that is political in nature, as one of the other witnesses spoke of. This is been tested by the Supreme Court of Canada. It is an absolute right without limit, and none of the other rationale that has been offered by you or by the other agencies that are represented here today offer exemption from constitutional powers of Canada's Parliament. Can you tell me if you have been granted, if PCO has been granted an exemption to the Constitution?
Successive governments have taken the same view in terms of production of document to Parliament. Going back to the 1973 principles governing the production of documents for Parliament, the government of the day tabled its position explaining exactly what could and could not be tabled to parliamentary committees. In 2010, the government of the day reviewed this and reaffirmed the same principles,
So,
which included being able to exclude things like legal advice,
The
cabinet
Supreme Court
confidence,
disagrees
privacy.
with you. The Supreme Court of Canada
the Supreme
disagrees
Court
with you,
in some
and I'm going to
cases-
reclaim my time. Thank you very much. Did the Prime Minister's office direct you to have your department not comply with the order of this committee?
Received no such direction.
Who coordinated the effort for you to speak on behalf of all departments about their active participation in a campaign to disregard the legal authority of Canada's Parliament to order the production of the documents that we did?
I would say I'm not speaking on behalf of all departments. I simply gave an opening statement in order to maximize the time for the committee.
It's very interesting. We often have multiple witnesses appear, and it's exceedingly rare that one would just, without discussion with the others, have elected to offer opening statements on their behalf, and that they would have nothing to add. So that's without coordination is extraordinary.
Is coordination. It was not direction. I think there's a huge difference. When we met as an ADM working group to talk about how we could best respond to this,
I haven't posed a question
there
to you,
was a,
but I do have a
request that I give an
Mr.
opening
Chair,
statement.
Mr. Chair, if I have a question for the witness, I'll direct one to him. But if he wants to interrupt, I'd encourage him to run for Parliament. And at that point, he might have the opportunity to learn a little bit about the powers of Canada's Parliament to send for persons and papers, which were just clearly articulated by the parliamentary law clerk. Sir, the redactions that have been offered by PCO and other departments are absolutely ridiculous. This committee had agreed to take these documents and receive them and review them in confidence and then make any redactions that were necessary. To claim that McKinsey is the one who requires the documents to be redacted, yet they've furnished the committee with all of their documents in an unredacted fashion, puts you at odds with the very same organization that you're professing to protect. In fact, it appears like there is political coordination by the Prime Minister's office through your department to ensure that there is not compliance with the laws of this country. How can you explain, other than the ministers giving their departments direction to defy the law, then how can you justify what other rationale you have arrived at that gives you the right to disregard the absolute authority, the legal authority, the constitutionally tested authority for the documents that have been requested of you to be tabled with this committee? That was a question.
I can only speak for PCO. PCO has received no such direction. We have followed the standards and the protocols that we always follow. In the case of these documents, of the 280 pages, we have 2 paragraphs which are redacted, and it is for cabinet confidence. In the original documents that we provided to you, we redacted additional information that was commercial confidence related to McKinsey. and 2 instances of personal information related to those who signed the contract. Subsequent to McKinsey providing its documents, we unredacted that portion. We also took the additional step of going to the 2 individuals whose privacy was there to seek their permission to unredact that. That is something that we have the ability to do. In the absence of their permission, we would have kept that redacted.
I find it interesting that you seek the permission of third parties and take that as instruction when the House of Commons has legally instructed you to produce the documents and you refuse to. And this is a serious problem. And the erosion of trust that this creates, that Canadians cannot trust government when government refuses to do what the people who are elected to represent them have asked to be executed on, when it is legal and reasonable for it to be done, and your department refuses because your department says they know better, that's unacceptable. And you said that you don't speak for the other departments, but you came here today, sir, offering statements on behalf of all but one other department. So that's why you're receiving my questions as the spokesperson. The minister responsible for your department,
Mr. Barrett.
the minister responsible for your department is who? The Prime Minister. Here on behalf of the Prime Minister.
Mr. Barrett, that is your time. Thanks very much.
Thanks.
Mr. Jouari, please, for 6.
Thank you, Mr. Chair. And as my colleagues indicated, Mr. Shi, it looks like you are now speaking on behalf of at least the group that's been here, excluding Mr. Ludwig. Naturally, you could sense the frustration within our committee. We are frustrated. We are somewhat confused, and we are disappointed. We are frustrated because we've asked a number of times through verbal, through communication, around what is it specifically we are asking the departments to provide. We are also frustrated when we see McKinsey is providing all unredacted documents, and yet we are challenged with being able to get the same level of information from our own department. We're confused as we are hearing two sides of interpretation, at least one by parliamentary law clerk and the other one by you, which I'm going to provide that opportunity to you shortly, around interpretation of the authority that the committee have. And we are disappointed because now we are investing at least 2 meetings over something that we believe it could have been avoided. Before I direct my line of questioning to you, sir, I just want to quickly go around because there was a question came that whether you were directed by anyone, specifically PMO or Prime Minister Office, to not provide any document or provide unredacted document. I think you've said no, but I just want to quickly go around the table, quick, just yes or no. We're starting with you, Mr. I can't see from here, Matthews.
Thank you, Mr. Chair. No direction provided to me from the political side.
Okay, Mr. Leduc.
None at all.
Madam Four, I believe.
No
Fox?
direction
No.
provided to me either.
Okay.
No. No direction.
Okay. Thank you very much. So I think we've all been. And you're going to hear the sense of frustration. But let's talk about the confusion. You've talked about 220,000 pages that by the time we are done, and it's going to be translated hopefully properly in both languages, and it's going to be made available to us at some level of on redaction, because I think there's still some hesitancy, despite all of these, to submit document with redacted document. Can you help us solve that confusion? Probably starting by the different point of view that you had around the interpretation of the Supreme Court, and you kind of talked about 2010, and then the Supreme Court. Can you help us? Because I'm definitely confused. I don't know. My colleagues probably that would help at least get this something out of this.
I'd first say it's not my view, it's the view of successive governments. And so it's not just the current government, it is governments that have come before then. And so, as I mentioned, in 1973, there were principles tabled on governing the production of documents. We certainly use that as one of the criteria in terms of what can and cannot be shared. But I think it's worth noting this was reevaluated in 2010 by the previous government, and the same outcome was a table document that made clear you can exclude legal opinions and personal information and cabinet confidences, solicitor-client privilege, that type of thing that we have consistently done across all departments. We're also guided by open and accountable government, which is something that every prime minister in recent years has had to guide ministers and to guide the public service. And I would read to you a passage from that, if I may, that says the public servants also have a duty to hold in confidence some of the information that comes into their possession in the course of their duties. There is a tension between that obligation and their possession, and the request of parliamentarians for disclosure of the same information. When appearing before parliamentary committees, public servants should refrain from disclosing that kind of confidential information, for instance, because the information is confidential for reasons of national security or privacy, or because it consists of advice to ministers. Accounting officers should not disclose confidential information, including advice to ministers, even where that information pertains to matters of organizational management. In practice, officials should endeavour to work with members of Parliament in cooperation with ministers and their offices to find ways to respond to legitimate requests for information from members of Parliament within the limitations placed upon them.
On that, so when we receive unredacted document from Mackenzie, and there should be a distinction drawn between what is the departmental let's say relevant content to that contract, because it may not have some of the cabinet confidential information. It may, and that's where, am I hearing it correctly? Then that's where some of this redaction is coming from?
So the redactions will be based on commercial sensitive information. So it's not the complete contract, it's sections. And so I can only speak for our department. We redacted banking information related to McKinsey and the signatories of the contract. That was the extent of what we redacted.
Thank you, Mr.
Okay,
Jouari.
thank you.
Ms. Vinola, please, for 6.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. You know, Canada is considered a country with 2 official languages, English and French. Many people just throw it back in our face that when I say we, I mean Francophones. This is a bilingual country, and we should be able to speak English. When I see the documents that are often translated into French, I say, well, where is this bilingual country? And a truly bilingual country, I speak French, the person I'm addressing will speak English, and we will understand each other. And that's my case. I can understand someone who speaks English, but unfortunately, the adverse situation is not necessarily true, and that's the same for documents. Most documents that I read have been drafted in English and then translated into French. Now, sometimes it's so badly translated that it almost makes my eyes bleed. So, I'll give you an example, a striking example. Deep dive analysis as dived for. I don't know if you can do analysis while you're scuba diving, but that's not my case. I mean, it's a silly example, but I find it in a number of documents. Now, the Canada Post Corporation, Madam Adjei, a neuronic translation instrument. I think that you're probably referring to AI, artificial intelligence, and sort of machine translation. But I've never seen a technology which has succeeded in attaining the degree of precision from one language to another. The best neural instrument is the brain, the human brain. So when I'm asked to make concessions on this thing, but make concessions on my native language I have to open both documents, and I have to constantly do a comparative analysis of the two texts in order to ensure that I understood correctly. And that's the type of translations that we've received. Some are good, very good. Others, well, with a few examples I've given you, it's almost ridiculous or cry, depending on your nature. When we received unredacted documents, it's not in my personal interest to read 2,000 or so pages and 47 others from McKinsey. I have 4 children, I have a family, and I'd like to be able to understand. I know that there are sensitive information. We don't want names and telephone numbers. We're not going to publish that kind of thing. We want to know what was the request of McKinsey in who's taking the decisions. Is it McKinsey or another consultancy firm, or is it our bureaucrats, our employees? We are quite willing to listen to advice, but the advice that's coming to the Parliament seems to be coming out of McKinsey's playbook. And we have a right to be worried and to ask for answers. I'm not here to put you up against the wall. I just want you to understand the importance of having an equitable treatment. Documents should be drafted in both official languages so that you don't disregard the needs of a portion of the population vis-a-vis access to information. So, I mean, I'm tired of being told if you really want to get the information, learn English. We often get that reaction. Well, preamble, here's my question. In your presentation, Mr. Shea, you said that you're quite willing to answer questions from the committee and that the translation in both official languages is a priority. Now, the 280 pages minus 2 paragraphs is what's concerned to you. If that is a priority, is that a priority to the other witnesses here? What hope do we have in receiving these documents, properly translated and unredacted, completely for the population that doesn't speak English?
Merci, Monsieur le Président.
Thank you, Chair. 2 points.
Interrupt you. We've got the vote bells are ringing.
Hmm?
Yeah.
About what?
Colleagues, can we agree unanimously we'll continue to 5 minutes before as usual? Thanks. Go ahead, Mr. Matthews. Sorry for interrupting you.
Pas du tout. Merci, Monsieur le Président.
Thank you, Chair. As for the national defense, we submitted all the documentation requested, all that we had in our possession in both official languages, and we used PSPC's services for the translation. So I'm assuming that they're of sufficient quality or good quality. We re-examined the redactions in order to ensure there are perhaps 5,000 pages overall, and of that, 350 which contain some redacted material. And we believe that that's adequate.
Colleagues, in case was not clear, Mr. Bedard is available to answer any questions you have from the members as well. Okay. Go ahead, Mr. John.
Well, obviously, the fact that the departments that haven't produced documents with redactions is hugely concerning. That's why we're having you here right now. But my goal and my frustration needs to be grounded in questions and getting answers and better understanding the issue and certainly precedents. So one thing, Mr. Shea, that you kind of highlighted with me was that there's history on this. So can you talk a little bit about, you said 2010 under the Conservative government, what they did in terms of how they responded in situations like this?
So the passage I read previously from Open and Accountable Government was from the previous government, and the exact same wording was continued for the current government. So again, as I've said from the beginning, this is not something that's unique to today. It's something that successive governments have absolutely enforced. And when it comes to cabinet confidences, this is something that even Parliament has reaffirmed in other acts, including the Access to Information Act, where cabinet confidences are excluded for 20 years, recognizing the important role that cabinet discussions have in shaping government policy. So I don't think we're presenting anything that's new. I think if you were to look back at transcripts from years ago, you would find similar arguments from the government of various days.
So did the Conservative government of 2010 release the documents unredacted when the opposition was demanding that that happen?
My understanding would be that in that time period, the exact same process as we're following today would have been followed in terms of the types of redactions.
So the answer is no.
The answer is no.
Okay, thank you for that. I took the time, and I really appreciate Mr. Leduc, who reached out to, I think, all members of the committee. Would that be correct, Mr. Leduc?
Maybe not all members, but we've attempted to meet
each
with
party.
all.
You reached out to each party.
Yes.
Okay, and I was responsive. I wanted to learn, and I think the whole issue here is I want to better understand why. And I don't have all of the answers yet, so I'm glad you're here today to answer some of that. But maybe, Mr. Leduc, can you please elaborate on why disclosing documentation to a parliamentary committee would be harmful to the Canada Pension Plan contributors and the beneficiaries, to our seniors and those that are retired? Can you talk about the impact that could have?
Thank you for the question. There are multiple potential impacts, and I'll start with a point of reference to why we were created. We were created because the Canada Pension Plan was literally going bankrupt. So in 1995, independently, the chief actuary produced a report and said by 2014 that we're going to run out of money. So one of the solutions was to create a firm, an entity that would expose the fund, not currently needed, to capital markets and global capital markets. And that means we have to engage all around the world with a wide variety of investment partners and portfolio companies. Even though we are a public purpose organization, it is 100% expressed commercially. The very root of what we do is dependent on confidentiality and non-disclosure agreements. That information, being accessible by our competitors could be very damaging. It could also lead to less trust us as a partner because of the sensitive nature. So that's the first thing. The other one is, and we could use Canada as an example, the world has changed in terms of what is seen as a patient, engaged, and productive investor going into a foreign nation. Even Canada treats sovereign wealth funds differently than it would treat a purely commercial organization. So using as an example, when we enter the U.S., we are dependent on a special, unique status that we have as an independent pension fund.
Would this violate that?
It would.
Okay. No, the provincial legislatures, they have the same constituents as us. You work obviously with them. Can you talk about any concerns they might have in disclosing this, and how come we haven't heard from them on this issue? Like, why are they not writing letters?
So
of concern
earlier
to the committee?
during the hearing, the Constitution Act of 1867 was invoked. Pensions under the Constitution is predominantly a matter of provincial jurisdiction under Section 92. And the only exception are those federally regulated entities. I think that's airlines and banks, for example. So when the CPP was created, it was created as a joint venture with the provinces who maintain, and that is enshrined in our enabling statute, the participation of the provinces is fundamentally preserved in how we operate.
Sure that there's accountability to us here at the committee, and to government and to Canadians.
Sure. What we try to do every day within CPPIB is, and this goes back since we started operating, so a quarter century, is to strike a very delicate balance between our public accountability and the commercial nature of what we do. And there's a wide range, including, obviously it's more symbolic, but tabling our annual report, in the House of Commons, which is full of disclosure. We also appear annually before the House of Commons Finance Committee. We hold public meetings with the public to discuss and let the public ask us any question that they want. The Office of the Chief Actuary resides within the Office of the Superintendent of Financial Institutions.
Do you understand the frustration of
Absolutely
not being able to ask direct questions and get answers
I
because of
completely
we're
understand.
accountable
I'm
to
afraid
the
that is
electorate.
our time, gentlemen. Ms. Kusi for 5 minutes, please.
Thank you, Chair, and thank you to our witnesses for being here today. Now, myself and my Conservative colleagues, unlike the Liberal and the NDP coalition, believe that our mission should actually be Canadians and their money. And this is why we asked for these documents, because we believed that this to me is just such a typical bureaucratic response. Canadians aren't smart enough to know where their money is going. That's just so incredibly unfortunate. And so we asked for these documents so that we could see the expenditures of these departments with McKinsey & Company. But in fact, it's no surprise that we received so many redacted documents. If I look at the unredacted documents we did receive from the BDC, we see that McKinsey charged $500,000 for 5 weeks of work for a strategic study. We see that McKinsey charged $160,000 per week for 4 weeks of work for an IT strategy. We see that McKinsey received $3 million, that's an M, million dollars, for 4 months of work for an advanced analytics and artificial intelligence project. That's a lot of money. We see that McKinsey & Company received $2.9 million for 4.5 months of work for a transformational launch. And finally, from BDC, we see that McKinsey & Company was paid $2.9 million for 12 weeks of work. That's $240,000 per week of work. This is at a time where Canadians are in a cost of living crisis. A recent survey by H&R Block found that 52% of Canadians feel that they don't have enough money left till the end of the month. That 46% of Canadians feel that they are on the brink of insolvency, defined as being $200 or less away from being able to meet their financial obligations. 1 in 5 Canadians said they were very likely to obtain meals from a food bank, and that a survey from the University of Saskatchewan suggested 20% of Canadians are skipping meals to cut down on food. Someone somewhere is missing breakfast, lunch, or dinner when we are having these types of expenditures. So I'll ask Madame Hudon from BDC, how can you possibly justify these large amounts when Canadians are struggling?
Merci, merci beaucoup, Madame la députée.
Thank you very much, Mr. Chair. Do you want me to answer now?
Merci beaucoup.
Thank you very much, Member of Parliament. The amounts that you've cited are, in fact, investments by the BDC, and you have to look at it as an investment in various projects undertaken by consultancy firms on subjects.
I'll go on to RCC. I see a total contract of $500,000 where a project leader received $73,000 for an unspecified number of days of work. We don't know if they worked 1 day, 2 days, 3 days to get that $73,000. We see a subject matter expert received $74,000 also for an unspecified number of days of work. In a moment, I'll ask Madame Fox how many days of work they worked for to receive those huge amounts of money. But we may never know, because I've got this chart right here, in fact, where we have large amounts of money from IRCC, where there are no estimated number of days required. How many days did the business consultant work to receive $390,000? We don't know. How many days did the project manager work to receive $195,000? We don't know. How how many days did they all work to receive $700,000 of taxpayers' money? And who led the plan for next week? We'll never know, because that name from IRCC is redacted as well. And I'll close in asking, or I should say in pointing out from EDC as well, that McKinsey Consultants charged EDC a weekly service fee of $216,250 for 10 weeks of work, Mr. Chair. We require these documents. It's our parliamentary right to have these documents, but more importantly, Canadians deserve these documents. Thank you, Mr. Chair.
Thanks, Ms. Cusi. Ms. Thompson, please, for 5.
Thank you, Mr. Chair, and thank you to the witnesses. And certainly it's an important committee today because we do need to understand why the documents were redacted and certainly in many instances why we didn't receive the documents. Mr. Shea, thank you for making yourself available as the main witness here, so I will direct my question to you. The McKinsey study production of papers is uniquely large, and it's covering over a decade of contracts with the company McKinsey. How many pages of documents in total do you estimate will be provided to the committee once all the departments, agencies, and Crown corporations have reported back to this committee? And do you have any sense of what the cost is?
I do not have an estimate of the cost. I think each individual department may or may not have that, depending on how they track their translation costs, which would be one of the major costs. And obviously, we do not always track the work of each individual employee against different projects, so that you may never be able to get that full cost. In terms of the number of pages, the number I've heard is 220,000 pages in total. I can return and confirm that number once I talk to other departments, but that's my understanding of the total number that we're talking about.
Thank you. So clearly this volume of documentation takes a tremendous amount of resources, and I realize that would be, that number would go across the different departments. But do you feel that this request has negatively impacted on government services that Canadians rely on?
I can only speak for PCO. It has not negatively impacted our services to Canadians. What any of these requests does do is take away resources that could be working on things like access to information for Canadians to access other types of documents, because it is so many of the same people that work on it. Where possible, we reallocate from other priorities to be able to have surge capacity. But absolutely, there's an impact on our ability to respond to other access requests from typical Canadians.
Thank you. And then can you indicate, or in a general way, the amount of time that's been spent providing documents for this study and a sense of the other work, which you referenced a moment ago, but if there's other work that would have been put to the side during the time needed to fill the request?
For PCO, it would not be a significant impact. We were talking about one contract and 280 pages, plus or minus, and so it would certainly work. We had to do translation and we had to do the redactions, but as I mentioned, there are not many redactions, and so I can't claim that this has been a huge burden on us. However, there are others at this table that had larger production orders, and certainly this would impact their businesses far more than us.
Thank you. And would anyone like to speak to the impact? Yes, Ms. Falk.
I can maybe perhaps give the committee a sense of scale for IRCC. So in total, we submitted about 23,000 pages in both official languages. And we had about 50 people working on the submission, so on the various tranches throughout this process. Now, there were 7 core team members that were kind of involved in all of the activities kind of on a full-time basis, but then there was a network of others who reviewed, including myself, who reviewed every tranche that came to this committee.
Could you provide the committee with any information on what impact this had on the other work within your department or the ongoing work?
Yeah, I think what I would say is, like, we take these requests extremely seriously, and we will dedicate the resources required in order to fulfill the request by the committees. And we also limited the redactions, but I think it is still important for us to dedicate those resources, and yes, pulling them away from their other responsibility, to take a look at ensuring that we're not releasing sort of personal information. Banking information is something that we found in tranche 2 of what we submitted. So the exercise of going through all those details is an important one, and one that we take very seriously. But I would say that, yes, we did pull people away from their day-to-day work to be able to submit, but we do think it is very important to do that.
Thank you. And to Mr. Matthews, and back to you then, Ms. Fox, the same question. Did the recent labor disruptions from the labor disruptions from the recent strike, did that impact the work requests?
I'm afraid you only have about 5 seconds, so perhaps you could provide that in writing to us, or perhaps answer in a later round. Ms. Vinola for 2.5 minutes, please.
Merci beaucoup.
Thanks once more. Mr. Leduc, I understand that your organization deals with very sensitive information, and we have to be aware of the fact that there are federal-provincial relations involved as well as international relations. So how many actuarials and accountants work for your department, your section? We have actuaries who are professional actuaries, but we don't have any in-house. They participate in our projects, but we don't really have any staff because we are at arm's length with the Chamber of Actuaries. Okay. So for advice, you have no actuaries on staff. They're all contract people, is that right? Working on the McKinsey issues? Well, no, the work on McKinsey is part of our investment package throughout the world. If we want to invest in a ABC company somewhere, we want to negotiate the best price possible for Canadians. So McKinsey will assist us in determining how we should approach the opportunity to invest with the best information in hand. Okay, thank you. Madame Hudon. I have a question, which is fairly straightforward, I believe. Is it normal that members of your organization use their personal email address to communicate with third parties, such as McKinsey, addressing them by their first name? Joe or Mary. Is that a current practice for individuals who are involved with your organization to send emails from their personal accounts?
Les échanges.
Professional correspondence are use only the official business address of EDC.
In half, we will suspend to go vote.
I'm going to go back to Mr. Shea. Mr. Shea, where is the line? When you're drawing the line on whether to redact a document or not, when it's in the public interest or government's interest, where do you find the line where I guess I'll start with that first of all. Where's the line?
So I think in each case we would consult with Department of Justice when it comes to making a decision to override, for example, personal information. So there are situations where personal information is released because it's in the public's interest to do so. When it comes to cabinet confidence, I think it's a much broader discussion and involves other consultations. But again, Department of Justice is really the lead for that, and it wouldn't be myself.
There's no political involvement at all in this?
There's no political involvement.
And same in 2010 under the Conservatives?
It would be the same under both.
Okay.
Now, for cabinet confidences, I believe the Prime Minister needs to approve that, but I would have to check that.
How do we know there's no things like in Ms. Vidon? I'm going to put you on the spot a bit, but the cost of the chauffeur, which I raised with you, your chauffeur when you flew him to Vancouver twice, which was almost as much as I spent in a year traveling to BC and back. How do we know there's more things like that not redacted? Things that the public should know about. How do we ensure that it's not hiding information that's going to embarrass the government, and that it's duly protected to protect the Canadian government and the taxpayer, and ultimately the beneficiaries, like Mr. Leduc talked about in terms of the pension plan?
I can't speak for every department, but I would say in general, and certainly at PCO, we have dedicated experts in doing these types of redactions. So it's the same folks that do access to information requests, and this is what they do, and they have no vested interest in one document versus another. They just want to be consistent in the way that redactions are applied. And so if there's personal information, it's redacted. If there's cabinet confidence, it's redacted.
Okay,
If it's
okay,
national security
okay.
and so on. But it's not about this would embarrass somebody versus not embarrassing. That is not part of the criteria.
Okay, Mr. Leduc, in terms of the impact on the Canadian pension plan, what is the potential impact? What, like, just bottom line in terms of the person receiving their pension, what could be the impact?
It would erode our ability to do what we've been doing, which is out of the $570 billion fund today, $400 billion is from our net profit. And our ability to be the leading investor in the world, which we are, based on financial performance over 10 years, requires us to be very commercial and very sensitive.
Okay, what's the cost of the compromise?
I'm sorry, gentlemen, that is our time.
$570 billion.
Mr. Leduc, I'm sorry, that is our time. We are, colleagues, we're going to suspend, and then we'll come back after, hopefully, one vote. Session. Witnesses, thank you for bearing with us. We'll start with, right back with Mr. Nader for 5 minutes, please.
Thank you, Mr. Chair, and through you, thank you to our witnesses for joining us here this afternoon. Mr. Shea, in your opening comments, you noted that, quote, you respect the role of Parliament. My concern is, and I don't say this facetiously, that I'm not sure you understand the role of Parliament. You mentioned in your opening comments, or in response to Mr. Barrett, that you're not a legal expert. Neither am I. I'm a farm kid from Logan Township. But when I don't understand something, I seek out experts. So my question to you is, what expertise did you seek out on parliamentary procedure and on the authority of Parliament to send for documents? I consulted in advance of appearing at this committee our legislative House planning team within the Privy Council office, along with our legal counsel, to refresh my memory on the protocols that are in place for dealing with parliamentary committees, along with the reasons that certain information must be redacted. So I did that consultation. Did you seek the advice of the parliamentary law clerk? I did not consult the parliamentary law clerk. I get the impression, sir, that you don't fully understand, despite the fact that you're an assistant secretary to cabinet, you don't fully understand the authority of Parliament. Parliament's authority to call for papers, to call for documents, is unfettered. You know, you'd mentioned about solicitor-client privilege. Are you aware that Parliament can call for any document that does go against solicitor-client privilege? Are you aware of that? So again, the government, successive governments have had the same point of view on this, which is that there are exceptions to that must be applied and have been consistently applied for several governments in a row. Again, sir, do you know what the difference is between government and Parliament? There's a separation clearly between the different branches of government. Are you aware that Parliament is supreme in its ability to call for documents? Regardless of what the government says, Parliament has its unfettered access to call for documents. I respect the role of Parliament, and I absolutely respect its authority. I must, at the same time, respect the legal opinions that have been provided by the Department of Justice and the time-honored traditions that have gone on between successive governments in terms of how to approach parliamentary document production. So the rules you're talking about are government creation. They are not a parliamentary creation, and Parliament's ability is not negated by a creation of government. I would draw your attention to a point made by Mr. Speaker Burkow at Westminster, where he said in relation to the rules that you are now citing, they are perhaps a matter of great importance in the minds of ministers, and in particular, I fancy, in the minds of officials. They are not important in my mind at all. Mr. Chair, I'm really quite flabbergasted that a senior official with Privy Council office would not understand or respect the ultimate authority of this institution to call for papers from an unfettered perspective. I'd like to ask Mr. Bedard, who is our law clerk, can you confirm that Parliament has the ability to call for documents in an unfettered process, even in cases, perhaps drawing on the example from last summer of Hockey Canada, even in cases of directing witnesses to, in some cases, go beyond what might normally be considered protected by solicitor-client privilege?
Through you, Mr. Chair, and thank you for the questions. As I indicated in my opening remarks, the power to send for documents in paper is rooted in the Constitution, is constitutional in nature, and will prevail over ordinary statute unless there's this explicit provision that would override privilege. Now, in the past, there are examples where there were initial resistance to produce documents. We can think of vaccine contract for the Public Accounts Committee. This is part of the public domain, so that's why I'm providing this as an example. Sir, you mentioned the study that the Heritage Committee was conducting on Hockey Canada. There was some resistance at first about providing documents that were subject to solicitor-client privilege. And after discussion, these documents were provided to the committee. And I will mention that the fact that solicitor-client privilege does not prevail over parliamentary privilege was recently recognized by the Superior Court of Justice in Ontario in the Laurentian University case.
Thank you very
Much for that great clarity. And I might add as well, for further reading, many of the authorities of Parliament, including Parliamentary Procedure and Practice, Beauchesne's, and other such documents would include much of this information, would they not, sir?
Yes, indeed.
Thank you. And so I would commend to our witnesses reading of the authorities of Parliament on this exact matter. How much time do I have?
That is it, Mr. Nader.
Well, I thank you for your time,
though.
Mr. Chair.
Mr. Baines, please for 5.
Thank you, Mr. Chair, and thank you to our departments for joining us today. I echo a lot of the frustration that our members have shown here, and part of our role is to ensure that we do things better. So I wanted, and I know Monsieur Leduc mentioned, get the best price possible for. So the cost is, of course, an issue of the work that we're doing here. So, based on TBS's preliminary observations of audit results from departments, the audits revealed no evidence of political interference and broad compliance with values and ethics commitments. However, there are indications that certain administrative requirements and procedures were not consistently followed. So departments have developed management action plans to address their respective audit recommendations. So the question I have for all of you actually is, do any of you have an update on how these management action plans are progressing to resolve the issues identified? So maybe we can start with Monsieur Leduc.
I'm going to have to seek advice whether that applies to CPP investments. There are a number of provisions, and I'll use an example, the Financial Administration Act, that does not apply, and these were conscious decisions that were made at the time when we were established. And I'm more than happy to come back to you very soon after this hearing.
Sure.
Thank you. I think we definitely take into account all information and advice and recommendations that were given by former auditor generals or procurement ombudsman. And so in the context of some of the action plan items, like perhaps the kind of looking at how restrictive some of the language around the contracts may have been, the department has undertaken to kind of take a look at that and make changes around transparency, around communicating outcomes as well. So I think, to your point, I think we do track our responses to the action plan, and we also leverage the expertise of departmental audit committees to challenge us in ways and reflect on our processes internally. Thank you very much.
I'm going to go to...
sorry, Mr. Baines, I need to interrupt. Sorry, we've got the bells ringing again. Colleagues, can we agree that we'll continue to 7 minutes before the vote? Wonderful.
I'm going to go to Ms. O'Gorman, please.
So our chief audit executive did find issues relating to the documentation of the contracts from McKinsey. So back in, and I will make no assumptions that some of those gaps and weaknesses don't extend to other contracts. So in January, I did ask for an audit of 100% of contracts in my organization. And a few weeks ago, in addition to the management action plan, did mandate 2 full days of procurement training for all executives who do contracting in the department. And so we do have a management action plan being developed with regard to the specific audit that the Comptroller General mandated. And we're also doing broader issues around that, and we will be tracking it closely. Thank you.
Mr. Shea, did you want to add?
So we had an audit done of our McKinsey contract, and it similarly found some issues around information management in particular, and safeguarding the original contract and making sure that we had some of the evidence on hand. Similar to my colleague, we won't assume that this is the same case for other contracts, but we can't say with confidence it's not. And so we've actually undertaken to review all contracts for the last year to make sure that there are no similar issues that have occurred there. And depending what we find, we may go further back. So we're taking a risk-based approach to make sure that we don't have any systemic issues. And we've already looked at close to 400 contracts in that review.
Thanks very much. So we did conduct an internal audit on the 2 contracts, one from 2012 and one from 2018. We posted the results on March 30th. There were no issues on those, but we do continue to monitor our contracts as we go forward.
Ms. Leary?
Thank you. So we are currently participating in 5 audits of the McKinsey contracts. There is one which has completed, which I understand was the PSP contract. We had no audit findings of that. Our chief internal auditor is participating in all the audits to ensure that if there are any findings, we would incorporate them into any management action plan.
And Mr. Matthews.
Thank you, Chair. The results of the audit at National Defence revealed challenges in some cases with completeness of documentation on the file. That is a very normal finding. It's something that requires, I think, constant reminding. We will be doing more checks to make sure the completeness is better, but the longer-term fix here, because it's very much still a manual process, is an e-contracting or an e-procurement system that is being rolled out across government, which has not yet hit Defence.
Thank you very much. Mr. Godin, welcome back for 5 minutes, please.
Merci, Monsieur le Président. En premier lieu,
Thank you, Mr. Chair. First of all, I'd like to check with Mr. Bidar, our legal clerk, if it's true that in committees, departments, and government agencies should present their documents to committees in both official languages. Is that correct, Mr. Bidar? Thank you for the question. Documents which are tabled in the House of Commons by departments and government agencies must be tabled in both official languages. It's a long tradition. Other agencies of government also table documents in both official languages for committees. But is that mandatory? You spoke of usage, practice, tradition, but is it mandatory? Is it obligatory on the part of departments and agencies on the basis that these tables are tabled in the House of Commons? They are in both official languages. If they are not tabled in both official languages in the committee is responsible for getting a translation and tabling them in House in both official language. And they have to be returned to the committee in both official languages. Okay, well, I'm going to be dealing with the both official languages. I think the transparency has been shown that there's not often the will to comply with this. I'd like to know, Mr. Shea, how does PCO act in the manner that they did for the production of documents? I'm just looking at C-13, both the Official Languages Act, the renewal. 3 situations would have impact on the departments. The Department of Finance, Privy Council, and Treasury Board Secretariat. They chose Treasury Board Secretariat 50-50. It doesn't necessarily reflect what the Conservative Party wanted, but vis-a-vis this situation, if the documents have not been translated or they were translated in a sort of artisanal fashion or using AI, because in some cases it was a mechanical translation, and in other cases you wanted to speed it up to meet a deadline. Other institutions still succeeded in doing proper translations. Does that not demonstrate a bit of willingness, if you will, or the use of bilingual, francophone, to in fact respect the traditions of Parliament?
All of our documents and provide them to the committee. And so we absolutely made extra efforts to ensure that all documents were provided in both official languages, as we always do. As I mentioned, to contrast with other departments, we had a relatively small number of pages, and so it was perhaps easier for us to do some of that. However, in situations where we've had large production of documents, we will use external vendors to supplement PSPC in order to make sure that we adhere to the requirements of Parliament.
Merci, Monsieur Shea.
Thank you, Mr. Shea. And you are with the PCO. And when you notice, you are the Prime Minister's office, if you will. Not his bureau, but don't you have an obligation to be guardian of the official languages in Canada and to set the example for other Canadian departments and agencies? Canada Post used machine translation, and they mentioned that they had to do so in order to meet the deadline. Does it mean that they didn't have the staff or the internal resources, and in order to meet a deadline, they used machine translation, which completely massacred the French language? Now, you also have the Canadian Pension Plan Investment Board and Investment Canada. I don't want to lose my time here, but don't you find that this sends a very negative message, a lack of intent? There's transparency and there's redactions of, but I mean bilingual, and we have to respect both official languages. I'm talking English and French here only. We don't get the same feeling from PCO that the willingness is there.
Perhaps you could get back to us in writing, please. As you may not be aware, since your last appearance, OGO has passed a motion requiring all responses within 3 weeks, just so you're aware. Mr. Housefather, please, for 5 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Chair. And I'd like to thank the witnesses for their appearance. I think my colleague, Ms. Vignola, made a very clear message on the need to have documents in both official languages of Canada simultaneously and of a quality where the two are compatible and equal. It's completely unfair to say that part of the Canadian constituency is inferior to the other. And I agree 100% with what you said. Mr. Shea.
With respect to getting some precision as to the position of the Privy Council office. So the policy that you were stated that I believe you said was adopted in 1973 and reaffirmed in 2010, who reaffirmed that? Was it the cabinet at the time?
It would have been the government that tabled it, I believe, at a parliamentary committee, if I'm not mistaken. And the open and accountable government, which I referenced, would have been approved by the Prime Minister in 2011 and then reaffirmed by the current Prime Minister.
I understand, but what I'm asking you is the policy that you're stating that allows for redactions to documents that committees call for. You use the word government. Who? Was it the cabinet? Was it the clerk of the Privy Council? Who approved the policy?
I would need to return to the committee to say exactly who submitted the policy. It was submitted to parliamentary committee on behalf of the government. If you're talking about the 1973 principles governing the production of government documents.
Yes, I would like to know, and I think probably others would like to know who the unnamed person was that presumes to speak on behalf of the government. So let me understand. What you're then saying is that you as the Privy Council office and you instructed other departments to follow that policy from 1973 and 2010, correct?
Privy Council offices encourages consistency across the government. Each individual deputy has accountability in terms of redactions for their own department, but we absolutely encourage consistency across the government.
Okay. And so what we're talking about is a competing understanding. Parliament and parliamentary committees understand that they can ask for documents. And I think we would all understand why cabinet confidences need to be redacted and perhaps some personal information. And perhaps there's times that attorney-client privilege would also need to be redacted. But I think the committee then would, in its discretion, make that determination in association with the department that was making that claim. In this case, it sounds like, irrespective of the advice of parliamentary counsel, somebody has taken a position that the government has a blanket right to redact these criteria. So let me ask, did a Speaker of the House of Commons ever agree with this policy?
I am not aware if they have.
So what would happen, sir, if the Speaker, let me just ask one other question. Are you maintaining that the policy that you are saying is the government policy would be the same in the event it was a committee of the House that asked for documents, or if the House of Commons as a whole voted by majority to compel the production of unredacted documents?
I think in any case, on a case-by-case basis, the government would seek counsel from Department of Justice and would make a determination of public interest for certain documents. There are certainly examples in recent memory where the government has allowed cabinet confidences, for example, to be used in a commission of inquiry, or examples where we have found alternatives, like in the health motion, to ways to allow members to view documents that would be national security in nature. And so I would say I think the government goes out of its way to find solutions, and I think in keeping with the open and accountable government, the last sentence of that is about working with parliamentary committees to find a path forward. Certainly, I think that is the view of the government, that we should do our best, our utmost, to find a path forward. In the case of the McKinsey documents, I believe we have done that. PCO, as we've convened different departments, has certainly encouraged us to minimize redactions and make sure that these are defensible redactions that fully adhere to the spirit of the rules. As you've seen, even in the case of Privy Council.
I understand. I'm going to reclaim my time now. I understand. What I want, I have only a limited amount of time. I've got to get some questions out. So to me, the way to then properly do that would be to enter into negotiations with the chair of the committee and the legislative clerk to talk about this issue, which I don't believe actually occurred.
Yeah, we're out of time, Mr. Housefather. Do you have a quick question they can get back to us?
Thank you, Mr. Chair. I guess my only question that if you can get back to me in writing would be to just ask, would it be possible then to get a copy, and I'm sure it would be privileged, but of the legal opinion of the Department of Justice that says that there is this ability to trump parliamentary supremacy when it comes to the production of documents? Thank you.
Thanks. If you're able to get back to us. Ms. Manola, 2 minutes, then Mr. Johns, 2 minutes, and we're going to go 3 and 3. We have to stick right to that, though. So please go ahead.
Merci beaucoup. Thank you very much. Well, I would simply like to inform those who are listening, yourselves, Ms. Fox, you said you had 50 people perhaps who were working on the analysis and translation or to ensure that it was okay. Well, we use the Translation Bureau services for the translation, so we had extra help. Well, 200 and so thousand pages. I haven't quite finished reading them all. I read them completely, in fact. I don't know about my colleagues, but I read those 2,000 some pages. And I'd like to understand that if I see a problem translation-wise, I will follow up with you individually if it comes from your department. Ms. Gorman, I see a contract here in English, and I'd like to know if it merits redaction.
Between line, contractor, a corporation incorporated under the laws of line with its address for notice for the purpose of this agreement as follows, line à la lines, in facsimile. So the lines are already there. I know les lignes sont déjà.
So the blackout is there. I know that perhaps it's redaction, but those sentences that I read, do you think that merits, that's worth redacting? Are the lines a comparison of, are they drafting notes, in fact? 001027, part 1 of the program. The sentence, in French, it has disappeared completely.
You can get back to us in writing. Mr. Johns, for 2 minutes, please.
Okay. Mr. Housefather had some good questions, Mr. Shea, about, terms of advice on ensuring there's transparency and accountability and not violation of parliamentary privilege. Now, he talked about meeting with the chair of our committee to try to fix this. You haven't reached out to do that? Do you have some advice for this committee, how we can, solve this issue and ensure that parliamentary privilege isn't violated, but we're also not putting at risk things like the Canadian Pension Plan and Canada's standing when it comes to investments like that?
So I do not know with confidence that there has not been any discussion with the department, with the committee clerk or the committee chair, as I know that is done in some cases. It's a different part of PCO, and I did not ask that question. So I can't say with absolute confidence that hasn't happened. I can continue to,
you know, like I think that's what we want out of today, and that's what we're trying to work towards. 2010 and this recent redaction, did either cabinet make a decision around redacting these documents? Whether it be now or in 2010 when the Conservatives were in power?
these specific documents.
The request for documents that were then decided to be redacted.
Forgive me, I'm not sure I understand the question.
Okay, I'm actually, because of time, I just really need to go back to Mr. Leduc. Mr. Leduc, you talked about the cost to pensioners. What could that cost be, the value of that?
What I would say is it's not about a specific dollar figure. Ultimately, it does come down to the value of the fund.
Could it be massive impact?
It would absolutely be massive.
Now, you reached out to everybody in this committee. Which parties met with you and when you were in your request?
We met with all of the parties except one, and one of the reasons we
Which one?
Which one we did not meet with?
Yeah.
The Bloc. Predominantly because the Quebec does not participate.
I
in the
apologize,
Canada.
but that is our
I
time.
appreciate that. Thank you.
Okay.
Thanks. Mr. Janice, for 3 minutes, please.
Thank you, Chair. The government's position is that it's the executive's prerogative to withhold documents from committees for certain reasons. Parliamentary Council has given us the opposite advice, namely that the constitutional principle of the supremacy of Parliament means that Parliament has the right to request documents. So you have two different positions. Normally, when you have two different positions in law, somebody makes a ruling about whose position is law, and when that lawful authority makes a ruling, people abide by it. So very simply, I'll start with Parliamentary Council. Who is the lawful authority in this case for ruling on whose interpretation of the law is correct?
When there's a claim of parliamentary privilege, and if the matter were to be referred to the court will examine the claim of parliamentary privilege, and once it finds that it is within an established parliamentary privilege, the court will refuse to entertain the question because it will recognize that the privilege is of the exclusive purview of the House of Commons or Parliament.
Exactly. And so who rules specifically on the matter?
The courts will rule on whether or not a parliamentary privilege exists, and there's already jurisprudence recognizing that the power to send for records and paper is an established parliamentary privilege.
Yeah.
Once the courts have made this determination, our privilege is exercised, that's for Parliament itself to decide.
And the Speaker will make a ruling on that.
Well, the House or committees will decide how to, the orders that they will issue. If an order is not complied with, the matter could be raised as a question of privilege.
Right.
And there could be rulings from the Speaker.
Right.
And there were such rulings in 2009, 2011, and 2021.
Exactly.
And I've all recognized the
right.
better.
So you have differences of opinion about law. You have the courts deferring to Parliament. You have speakers making rulings, and you have Speaker Milliken and Speaker Rhoda, both, if it matters, elected as Liberals, making rulings that protect the privilege of Parliament in different points in time. So very directly, back to Mr. Shea, do you recognize the lawful authority of the Speaker and your obligation to comply with the Speaker's rulings, whether or not you agree with them?
So it's not about whether I agree with a ruling or not. This is the government position.
So the government doesn't agree with the rulings, right? But they lost, right? Like they made their case to the Speaker, they lost. The Speaker made a determination that they were wrong. So don't you think you should comply with the law when the Speaker rules and is the lawful authority as we've established?
So again, I would have to take that back to our legal counsel who ultimately make determination, but I will say...
I'm sorry, I'm afraid that is our time. We're sticking right to the dot because we have to go vote. Mr. Kuzmierczak, please, for 3 minutes, then we will adjourn.
Thank you, Mr. Chair. And again, I know that it's already been established here, sort of the frustration of committee members around the table, really from all parties. We want to maximize the amount of information. We want to maximize transparency. I think we are all united. And I think we're all united in our frustration in terms of not being able to receive the full documents that we had asked for. But I do want to understand what I want to do in this committee room is also understand your concerns as well too. And so what I wanted to ask is just to put this in context, sort of this debate that we're having here, is this committee's request unique in the sense of asking for fully unredacted documents? Is this something, and it's a question to Mr. Shea, but it's also a question to other members here around the table, is this a unique, I mean, committees always ask for production papers. This is something that's just standard. Is this unique in terms of asking for fully unredacted documents? Is, I guess, what I'm trying to understand here.
You'll forgive me that I don't know what other committees have asked for unredacted documents. I think our position has been consistent, though. When asked to produce documents, we produce them in both official languages and with appropriate redactions.
If I could ask that question of some of the other folks around the table as well, too. Is this unique, what we're asking for?
I'm more than happy to say that it's unprecedented for us. We are not part of the federal government, so just to be very, and put that on the record. And so this has never happened before.
I would just say, with respect to IRCC, I think that we consistently try to reconcile sort of the parliamentary committee request with the other acts in which we must abide by, whether that be privacy or other types of sensitivities. So I would say this is probably not the first time that we've kind of encountered this type of challenge in that context, but I think what we try to apply is looking at the most minimal ways. And I think personal information and the Privacy Act is something that we have to be very sensitive to, and I think it's balancing both the objectives of the committee with some of our other obligations that we must adhere to. Thank you, Mr. Chair.
I would just say +1 to that comment. I think really trying to be timely, complete in the work that we're doing, and really the size and the pace at which we were hoping to, that we were working as we tried to get information as we have into the committee in both official languages was really our priority. But consistently, you know, the imperative ensuring that Canadians and the people with whom we work can be assured that when we have their information that we will keep it private. I mean, that's consistent with the laws that Parliament has passed and our objectives when we're working with them so they can have confidence in us.
That is our time. Witnesses, thank you very much. Colleagues, we will adjourn so we can go vote.